the number one thing that can prepare you to be a lawyer is actually working in food service or fast food or fine dining. Working at McDonald's is great to be a lawyer. Why? Because it teaches you how to interact with people. Practicing law, for the most part, is about interacting with people. Somebody majoring in fashion merchandising might be somebody that a law school would look for because they're looking for a diversity of people. People that go into pre-law. What is pre-law? It's kind of a nothing major. It means that you want to go into law school. And I'm going to tell you right now the thing that we're not supposed to tell you. It's actually quite easy. They tell you, oh, don't read the horn books. Don't read the Cliff's Notes versions. Guess what? Read the Cliff's Notes versions. As an attorney, anything that you can do that makes you faster, more efficient, and that has been thoroughly done and analyzed, read those thorough analyses. You're going to learn how to think like a lawyer. One thing you can do for law school is get the bar study books and start studying for the bar exam like 6 months before you even go to law school. And so the best way to study for those, are actually the most efficient and time-efficient manner, is read the answer and then think about what the question could be. Then go back and read the question, because that will actually open up a better memory location in your mind. Malum in se is it's bad because it's bad. Malum prohibitum means it's bad because it's prohibited. For example, a lot of people would say marijuana is malum prohibitum, meaning it's only bad because it's prohibited. Otherwise, it's not bad in itself. Whereas murder is malum per se because it is bad in itself. Real lawyer reacts to a real lawyer reacting to Legally Blonde.
I was thinking maybe we could go out sometime.
No, you're a dork.
I'm in law school.
Oh boy, I'm in law school is a terrible pickup line.
Yeah. In fact, when I was in law school, that was one of the lowest and worst times of my life about picking up girls.
At least, I don't think it's a good pickup line.
It's not.
Is it a good pickup line? Have I wasted my life?
Now you're thinking like a lawyer.
All right. I'm the real lawyer reacting to the real lawyer. And maybe he'll react back to mine.
Hey, Legal Eagles, it's time to think like a lawyer because...
Unfortunately, I think like a lawyer all the time. As a matter of fact, since law school, the whole objective is to try and stop thinking like a lawyer. I think they do something to poison your brain. You get paranoid about everything. You look at it all under the context and the lens of being a lawyer. Yeah, it's a problem. I'm trying to be a real boy again. Pinocchio was better off wooden, I think.
Today we have a special treat. We are covering perhaps the most highly requested legal movie of all time on this channel, Legally Blonde.
I've waited so long to hear you say that.
I have a special connection to this movie, and I was saving it for something special, and that time has arrived. LegalEagle has 1 million subscribers,
nice.
Which is just incredible. A lot of laws have been broken along the way, and a lot of hashtag not legal advice.
All right, so if you're subscribed to LegalEagle, it would be a good idea to subscribe to the Lawyer Dana podcast. Quick plug.
Has been handed out.
Yeah, this is not legal advice. Anything that you see in our channel is not legal advice. It's for informational purposes only. If you have a legal problem, you should contact an attorney immediately and speak to them in a consultation.
So without further ado, let's dig into Legally Blonde. Put on your pinkest tie.
Oh, I need my pink tie.
This is gonna be just like senior year, except for funner.
Find your fluffiest dog.
Fluffy dog. Check.
And let's get in to Legally Blonde.
I plan on running for office someday.
And I fully support that, Warner. You know that, right?
Absolutely. But the thing is, if I'm gonna be a senator by the time I'm 30, I need to stop around.
We had not many, but some people in law school that were like that.
Yeah, so the US Constitution says that to be a senator, you have to be at least 30 years old, so he literally cannot be a senator before he turns 30. This guy is kind of a dum-dum.
You have no idea the pressure that
happens.
I am under. My family has 5 generations of senators. My brother's in the top 3 at Yale Law.
So that would be a big deal if one's brother was in the top 3 at Yale Law School, because although Harvard is probably the most well-known law school in the country, Yale is continually ranked the best law school.
Which, by the way, all those rankings are just a bunch of nonsense, really. If you want to go into politics, sure, there's a lot of connections and things there, but how much does that mean? Not a whole lot. If you go to any of those 3 and you're in the top 10%, then you're going to do fine. If you're in the top 10% of any law school, you're going to do fine. If you're one of those top people at any law school, you're going to do fine. But how much do the rankings mean? Not a lot. It's mostly just marketing stuff for them to get people to pay and take out maximum government loans and make a whole bunch of money.
In the US, Yale sends more people to the Supreme Court, more people clerk for the Supreme Court, and Yale is generally considered slightly more prestigious than Harvard, even though Harvard is probably better known. So yeah, that would be a big deal.
So you're breaking up with me because you're afraid your family won't like me?
Kind of dumb, because that's Reese Witherspoon, and she does quite well.
Everybody likes me.
Well, East Coast people are different.
East Coast people are
That's
different.
true.
True that.
Harvard Law School?
That's right.
But that's a top 3 school.
Oh, I have a 4.0.
Yes. But your major is fashion merchandising.
The interesting thing is that somebody majoring in fashion merchandising might be somebody that a law school would look for, because they're looking for a diversity of people that go into pre-law. What is pre-law? It's kind of a nothing major. It means that you want to go into law school, and it probably means that you're sort of a limited person. They look for people that have experience in a wide diversity of type of fields. So the fact that she's in fashion merchandising could be advantageous, actually.
Okay, so this is a pretty common misconception that to go to law school, you need to have some pre-law major or you have to be a poli-sci major. Law schools, in my experience, really don't care that much about what your undergrad major is, because none of those majors really prepare you for either law school or becoming a practicing attorney. So
real life experience. In fact, the number one thing that can prepare you to be a lawyer is actually working in food service or fast food or fine dining. Working at McDonald's is great to be a lawyer. Why? Because it teaches you how to interact with people. Practicing law, for the most part, is about interacting with people. Now, is there some kind of percentage, 25, maybe 50% or something, of lawyers that are back office lawyers, the total non-interactive type of person that it doesn't deal well with people and just hyper technical on law and just sits in their little cave and does their paperwork? Sure, that exists. But for the most part, the more personable and more social skills and more service oriented that a human being is, the better that they're going to perform as a lawyer.
the fact that Elle has a degree in fashion merchandising probably won't matter that much at all. In fact, it seems like she went to a good school, the same school that her boyfriend went to, so I doubt that her particular major is going to have much of an effect. Now, on the other hand, it could actually help her. Exactly. Law schools are inundated with people who have a political science degree or English major.
The fact that she had a fashion merchandising degree and applied to law school would be something that would make her actually stand out, probably. Now, am I saying, hey, if you want to get into law school, go into fashion merchandising? No, I'm not saying that either. I'd actually say go into something that you're interested in, that you're going to do well in, and then if you want to become a lawyer and go to law school, then apply and see what you can get. Although, if you had a degree in fashion merchandising, it seems like you might want to go do some fashion merchandising and not put yourself through the torture that it is to go through 3 years of law school and possibly do something that you're not going to like a lot.
Or history majors. So if you have a degree that is interesting and stands out or shows you want to go into a particular legal specialty, then that can actually help you get into law school. But for the most part, your undergrad major has no effect whatsoever.
What are your backups?
I don't need backups. I'm going to Harvard.
That's pretty bold, but I think realistically, the guidance counselor is more accurate. I think Harvard takes, what, 3%?
Well then, you'll need excellent recommendations from your professors.
Okay.
And a heck of an admissions essay.
All right, so that part is true.
Yep.
Law school, almost everyone uses the same online system, and in order to complete your application for most schools, you have to attach at least 2 letters of recommendation.
Typically, you want to get really good letters of recommendation, and what law schools, unfortunately, are impressed by are things like letters from high-level type of people. So the more impressive that your letter of recommendation is, it's sort of a little bit the content of the letter, but it's mostly the credential and the credibility of the person who's writing it. So if you're getting a letter of recommendation from the President of the United States, that's going to go a lot farther than it is from your high school principal. But your high school principal is probably going to go a lot farther than maybe a teacher. One of the problems that law schools have is they highly weight and are very conscious of social credibility, because anything that gives them credibility to say, well, our students have these credentials, these credentials, these credentials, it's all bragging on both influence and authority. And so anything that carries weight in those aspects is going to help you out quite a bit.
And using that same online system, almost every law school requires a personal statement, which is an essay that you'll submit to those law schools.
And at least a 175 on your LSATs.
175 on the LSAT, especially back then, is very, very high and very, very difficult to get. But that's probably accurate.
Yeah, so a 175 on the LSAT is a very, very high score. And that is exactly the kind of score that you need to get into that school. Now, the LSAT is judged on a score from 120 at the bottom to 180 at the height. I have no idea why they chose those particular ranges, why it doesn't go. And if you're anywhere above 170 out of 180, then you're in the 99th percentile of all LSAT test takers. So your chances of getting into Harvard at that point are pretty good.
Most of what they are looking at is those LSAT scores plus your GPA, because what they say is our average GPA is a 3.985 and our average LSAT is 172. So they are saying our average GPA and our average LSAT is higher than these other classes and courses around. So it's extremely important. If you're somebody that's above the school average, that's the type of person that they're looking to, because they want to just improve those scores, because that's how they get those rankings that say this is the best law school, this is the next best law school, this is the next best law school. It's one of the most important factors. So a lot of it is just your number on paper and how you're helping their numbers.
You're gonna need this. Your scrunchie? My lucky scrunchie. It helped me pass Spanish.
I've seen some people that will dress really nicely for a test because it's mindset setting, and if they're of that mindset, it helps their own self-image, and it can actually help them to answer and trust their instincts on tests before. A lucky scrunchie handed by somebody else, I don't know. That's a little bit more superstitious than anything, but okay if it works.
You passed Spanish because you gave Professor Montoya a lap dance after
Okay, so that's more of a reason.
the final.
Yeah. Luckily.
Oof, that does not age well.
No, it does not.
Oh, hi. My name is Elle Woods, and for my admissions essay, I'm going to tell all of you at Harvard why I'm going to make an amazing lawyer.
All right, I'm sure I don't need to tell you that it's not appropriate to send a video version of your admissions essay.
Especially in a bikini. They are not looking for somebody like this. They're looking for somebody that's probably very conservative and appropriate and not going to bring any kind of disgrace to their school.
In fact, there's no way to upload that onto the law school application system.
And honestly, I think a lot of the admissions departments in universities are made up of females as well, not necessarily stuffy old guys like they're portraying it in here. I don't remember this scene either. None of this is aging well, but let's see where they go with this.
And if you did mail it in, they'd probably just throw it directly into the trash. So there is a
No, they wouldn't. They'd keep it in as part of your file of why they're turning you down.
time and a place for thinking outside of the box, but your admissions essay is not that time and it's not that place.
A. Neither type of opera or neither type of rap is on sale. B. Neither type of jazz and neither type of opera is on sale.
So what they're hinting at here with this dialogue is a specific type of question that actually does show up on the LSAT. It's called a logic game. And generally you're given a fact pattern with a bunch of logical variables, and you have to use logic and other tools to find out the correct answer based on different things that happened in the fact pattern.
And the reason why they do that is because that's what you're doing a lot as a lawyer. You have the format of here are the elements of what law is, and you have to take facts and determine how they apply to the law and whether or not the facts on the law match up. Or not. And a lot of times people think that it's about a certain amount of things when really the actual law is looking at a bunch of other different factors. So it's really important that lawyers can process logic in that way. Otherwise, if you have a lawyer that can't do that, you got a problem.
And these are the kinds of questions that people tend to have the hardest time with because they require problem-solving mentality and certain problem-solving tools that people just don't necessarily know intuitively.
And that's what we talk about thinking like a lawyer. It's that type of thing that they ingrain into you during law school that just fundamentally changes you for the rest of your life.
So you have to learn that with an LSAT class. And there's a whole cottage industry of people that try and teach you how to do well on the LSAT because it's such a counterintuitive test.
3, get set, and go!
This is actually a pretty good scene. It's showing that she's taking practice LSAT exams before she takes the actual LSAT. And what's even better is that she's not just taking her practice exam in a deadly silent room, but she's taking it in a room with a bunch of distractions, which I think
Great way to practice.
practice LSAT exams before she takes the actual LSAT. And
Yeah, you should.
although
really, the LSAT is essentially an intelligence test. It's an IQ test. I've seen people do really well without studying. I've seen people do poorly with studying. I've seen people get better with doing a lot of studying. But in general, it's hard to study up for the LSAT. You're only going to probably improve 5 points, maybe 10, if you really, for example, had a bad day or you really learn how to take tests well. And the other thing is that on your practice tests, you're usually going to do better than you actually do in the actual LSAT. I don't know if that's on the part of the companies that they make the practice LSATs a little easier to give you enthusiasm going in, but if you really want to get into Harvard, for example, or one of the supposedly better and higher ranking law schools, then yes, absolutely study for the LSAT. The other reason, which is actually more of a reason to study for the LSAT, is not necessarily what college you're going to get into, but is how much money that you're going to get. Because if you're one of those people that is going to be raising the law school's LSAT average score, because like if they're normally getting a 150 and you have a 165, you're going to be highly contributing to raising their average. And they can admit somebody that maybe they want to admit that really looks good on paper but has a lower LSAT than the average. So you're going to offset that one person. Or if you're 15 points ahead of the school's average, then they can admit 3 people at the average, and you'll help raise their average score up. So the better that you can do on the LSAT, the more likely that you're going to get to go to law school cheaper. And honestly, you want to go to the best law school that you can get into for free. Law school is about getting out without financial damage to yourself. If you're coming out of law school with $300,000 in debt, it's going to be extremely difficult for you and very unpleasant for a number of years, because it takes a number of years before your income starts to exceed even the value of what law school was. Well, and if you're at 6% or 7% interest or 8%, depending on what interest rates do, and you're financing $300,000, 8% at 300, 8 times 3 is $24,000. So you're going to be paying $24,000 a year just to maintain the same balance without even paying it down. So and a lot of times the starting salary for a lawyer is $60,000. So if you're paying $24,000 in interest, that's out of your $64,000. That's only $36,000 to live on as an attorney coming out. And you're thinking to yourself, "Oh, I just got out of law school. I'm rich and famous now." You're not. You're not going to be for 5 years, even if you're making good money, because you got to pay those loans back. So to go, if you're applying to a law school, to go to one that's maybe ranked a little bit lower, but that you can go to for free, unless you're going to the top 3, it doesn't matter where you go to law school. It really doesn't. No one has ever asked me, "Hey, Dana, what law school do you go to?" "Oh, I went to SMU." Oh, okay. Sometimes they'll ask, and if it's somebody around here, because I'm still in the Dallas-Fort Worth area primarily, then they'll maybe be impressed. "Oh, you went to SMU, which is cool and great." Yeah. Or you went to Baylor, or hey, you went to Texas Southern, or you went to University of Houston, you went to UT Austin. It's trivial. It doesn't matter. No one's either hiring you or not hiring you based on what law school you go to. The purpose to go to law school is so that you can sit for the bar exam. The purpose to sit for the bar exam is so that you can get a law license. We all have the same law license. It only depends what you do with that license. And kind of sort of maybe the first job that you get coming out of law school, and kind of sort of maybe how much you make coming straight out of law school. But to pay $100,000 more for that difference coming out of law school, totally not worth it. You're not going to get that back. So it's much better for you to save $100,000 or $200,000 and go to a law school that's going to give you a scholarship, rather than go to the one that, "Oh, I like their school colors." Like, don't make that mistake. And their reputation, "Oh, they're higher ranked." No one's going to care. It's not going to make a difference in your life at all. We all law school is just a prerequisite to get a law degree. And your law degree, from as long as the school is ABA accredited. Now, there's plenty of places in California. In California itself, you don't have to go to an accredited law school in order to get a law license. But if you go to a non-accredited school, the chances of you passing the bar exam in California, I think their passage rate is like 20% for non-accredited law schools. And the California bar passage rate is lower than most states. Why? Because they let people from non-accredited law schools go there. And if you go to a non-accredited law school, the reason why they're not accredited is because they're not teaching to certain standards a lot of times, or they're admitting just anybody and people that really shouldn't be admitted to law school because they're not going to be able to pass the bar exam. And you spend 3 years of your life and then you fail a bar exam 5 times and you never be a lawyer. What was the point? And you've wasted a whole lot of money. So it's much better that you go to an accredited law school. Plus, you don't only want to be able to practice in California. And if you've gone to an accredited ABA law school, American Bar Association accredited law school, then you can get a law license in any state, and you may have to take the bar exam in different states, but that's the point of why the LSAT is important, because they're trying to screen out people that aren't going to be able to pass the bar exam.
When you're taking the LSAT, or any test for that matter, you're not taking it under ideal circumstances. Things aren't going to be perfectly silent, which is often the way that we study for exams and the way that we take practice exams. So you're likely to do better if you practice in an environment that is not conducive to actually doing well.
So that's magnificent and genius level. I'm not sure if how many people I've ever even met that have done a 179. Not that it's like something that you talk about a lot, but that's incredibly good for an exam and realistically pretty close to impossible. Some people have done it, yes. So, but at this point, if that's what she did get, then she's probably a genius.
A 179 on the LSAT would be an extraordinarily high number. Basically a perfect test. It means out of the 100 or 101 questions, you might have missed 1 or maybe 2 questions in the entire exam. Of course, this was recorded before the LSAT required a written portion of the exam as well. At the time, it was all multiple choice. So, good job, Elle Woods. That's very impressive.
Wait a second, my social events calendar is missing.
My social events calendar. So I don't know. So when you get to Harvard, and Ben Shapiro went to Harvard and tells this story about how right when you're there, your first orientation, they welcome you into a big room and they go, even the worst of you, congratulations, you have made it. You're the elite. Because anybody that goes to Harvard Law School gets whatever job that they want because they went to Harvard Law School. I can, especially if you're going to be at the top of your class, the workload is absolutely monumental of what you would have to do. She would not have time to do anything except intently study. And it's almost maddening how much that would take. So for her to have a social schedule, and the fact that she would have to have a photographic perfect memory, able to process things at phenomenal speed. She would have to have just an IQ, I guess, out of this world, but a 179 on the LSAT does that for you. But to be able to have social interactions and things at the same time, she would be a heck of a person in doing that.
You're what?
Social events, mixers, formals, clam bakes, trips to the Cape.
So if you're doing all that, when are you reading I'm not kidding. It's a stack that would be taller than my bookcase here, worth of things that you would amount of reading that you would have to do. I mean, I don't know. I guess your books first semester about waist high, maybe. I remember that they wouldn't all fit in one backpack if you were reading it. Plus, knowing what to study, plus running and taking all the practice tests and exams in order for you to be at the top of the class. If you wanted to be at the top of the class, it's a lot.
Yeah, so they're making the joke about law school that there's a lack of social events because that's largely true, especially in your first year of law school. 1Ls who are first-year law students are under so much stress that there's really not that much time for social activity.
And the other thing, one thing you can do for law school is get the bar study books and start studying for the bar exam like 6 months before you even go to law school. Because your first semester class are all those bar classes like contract, torts, criminal law, civil procedure, constitutional law, property law. All of those courses are very, very standardized through almost all law schools. And there's tons and tons of multiple choice questions that you can do. And so the best way to study for those, are actually the most efficient and time efficient manner, is read the answer and then think about what the question could be. Then go back and read the question, because that will actually open up a better memory location in your mind for you to remember and see those things. And it will help teach you the fine line distinctions that are taught during your law school classes. And I wouldn't even necessarily read for the classes either before school. I would simply just go in and start practicing those practice problems. It's a lot of the way that I study now on Duolingo, to go through and just look at those, like a Barbary book, which Barbary was one of the ones that I did when I was in law school. And so they had a red book and a blue book. And so they were about this thick and just full of nothing but practice problems. So read the answer and then do the problem, and probably the fastest and most efficient way. And it also gives you a good structure for those outlines of what the first semester classes are.
Sometimes you do what's called bar review, which is usually on Thursday night, which is not actually reviewing things for the bar. You're just going to a bar to drink. So if anyone says they're going to bar review, that's what they're talking about. That being said, as 2 and 3L, your schedule does open up a bit, so you have more time for recreation.
That's when you realize, so there's 2L second year and 3L third year. That's where you realize that most of what you're there for is, how do I say, B and because what you realize is, hey, I just need to get the structure and order of the law. Most of the time, people on their second and third year realize, oh, all that reading, all that stuff that they told you that you have to do as a 1L, you don't really have to do. And the sitting there and briefing all the cases, they're trying to teach you how to read a case and what to look for when you really don't know anything about it. There are canned briefs and outlines and things. These cases have all been briefed thousands of times. And I'm going to tell you right now the thing that we're not supposed to tell you. It's actually quite easy. They tell you, oh, don't read the Horn books. Don't read the Cliffs Notes versions. Guess what? Read the Cliffs Notes versions. As an attorney, anything that you can do that makes you faster, more efficient, and that has been thoroughly done and analyzed, read those thorough analyses. You're going to learn how to think like a lawyer. You don't have to worry about that. You don't have to put yourself through the hell process that everybody falls for. It's the trick. It's the secret that we're not supposed to tell you. I'm telling you the secret. If there's anything that speeds you up, if there's a shorthand version of it, do that shorthand version of it, and then try and memorize everything as it relates to the outline. The things that you have to memorize are things like, in a tort, you have a duty, a breach of the duty, proximate cause, actual cause, and then damages. And you have to go through those elements and know what those elements are, and then just be able to analyze that. And a lot of times they're trying to give you all these red herrings and distractions to make you think that it's something that it's not. In essence, law school actually is very, very easy. The problem with law school is most people don't figure that out until the second, third, fourth semester, but almost everybody does figure it out. And then by the time you're studying for the bar exam, you realize, oh, I just have to know this structure of these elements, and just do practice question after practice question after practice question. In law school, they use this thing called the Socratic Method, where they want you to figure out what questions to ask. So they ask you questions about it that lead you from one to the next logically. When in reality, if you realize that that's what they're doing, you can just cut to the chase and say, just give me the answers. What's the duty breach? I don't care about the history. I don't care about necessarily why this came up, because you're going to get that. You're inherently going to know a lot of that stuff. And a lot of times in class, people are going to argue about what policy should be. I assure you, you're not going to be tested on what policy should be. You're going to be tested on, can you regurgitate it and can you apply it to the facts and circumstances? So, I digress.
And there are things like law school formals and dances and get-togethers and, still more bar review for drinking because it's, law school. But
you might have something once a week where you go out and do like an hour worth of something. More likely you're going to go out once every 2, 3, maybe 4 weeks, and you'll go to some kind of function. And but for the most part, you're just working your tail off.
But there are actual social directors and things like that. So it's not crazy for her to have assumed that there would be actual social activities, even as a 1L.
This is the part where we go around in a circle and everyone says a little bit about themselves.
Hey, how you doing? I'm Enid Wexler, got a PhD from Berkeley in Women's Studies, emphasis in the history of combat. And last year, I single-handedly organized the March for Lesbians Against Drunk Driving.
Killer.
Thanks. Good times.
Yeah, so there you have yet another person who doesn't have the standard pre-law degree or poli-sci degree. Law schools love to have a diversity of thought and a diverse student body. So that's a great example of someone who's not your run-of-the-mill law student, and yet they're theoretically going to Harvard.
A legal education means you will learn to speak in a new language. You will be taught to achieve insight into the world around you and to sharply question what you know.
That's true.
That is very true. I would say that one of the most important takeaways I had from law school was just to dig deep, to be skeptical, and to make sure that you check out all of your premises before you jump to a conclusion.
Yes.
So in that respect, this law school professor seems to have a handle on things.
Does anyone know who spoke those immortal words?
Okay, so the guy who just raised his hand, that's what we call a gunner. He is the person who's every question raising their hand, and he is just on those guns. That's what we call them, gunners.
Yeah.
And what they have wrong in this is that dude would be in the very front row. Usually the gunners are not maybe so far back, but I don't know, some of them.
Aristotle.
Are you sure?
Yes?
Would you be willing to stake your life on it?
I think so.
That's impressive.
What about his life?
Ugh.
Yeah, this is a style of teaching I also don't particularly like, but it's the Socratic Method. Here you go.
God, I hate this style of teaching, but I've also had professors who had a similar teaching style that was very aggressive, very much about breaking the student down before building them back up again.
Yeah, most of what law school does is it crumbles the person that you used to be and then turns you into dust and then reassembles the dust into this new thing that they want to create.
I happen to think that this is a terrible way to be a professor, but unfortunately this style of teaching does exist. So I can say that this repartee is not completely unrealistic. It has happened in front of me before.
Yep.
Now, I assume all of you have read pages 1 through 48 and
Yep, that'll happen too. And it won't just be page 1 through 48. So maybe on the first day, it was a surprise that you didn't even know that there was an assignment of 1 through 48. I don't know. My mom passed away on my first day of law school. So the very, very first day, I missed one day of orientation. So I was a little bit off on a couple of things. But yeah, on the first day you walk into school, they've got a major assignment for you. And I got to tell you, though, most of the time it wasn't page 1 through 48. A lot of times it's page 1 through 148, about 150 pages per class, multiple classes a day. It's a lot.
now well-versed in subject matter jurisdiction. Who can tell us?
So that look where you're looking around and going, what the heck is, how do they know this and I don't? I had a lot of that in law school. Again, I missed that. I was there for the first day of orientation. My mom passed away. I missed the second day. I was there for the first day of class, which was on Monday, but I know exactly what this experience is like.
About Gordon versus Steele.
Oh my God, the Socratic method of teaching. I'm getting PTSD just thinking about it.
I hate
So
it.
in a nutshell, the Socratic method is based on Socrates, who went around not so much pontificating, but asking questions of his students until he revealed so-called deeper truths through these questions that went far below the surface.
And you just want like, hey, can you just tell me the answer? Tell me why. They go so important on a lot of the trivial stuff. I mean, I get why they do it. They have to justify their existence to a certain extent. And I don't know, maybe the crumbling down of the law student, breaking them down and then putting them back together in the way that they want so that you analyze law correctly. Maybe that's good. But yeah, thanks. We hate it. All law students, correct.
This is a style of teaching that you'll find in most law schools.
Yep.
I don't know why, but law schools tend to be the last bastion of educational places that use the Socratic method. Nobody seems to do it. It's really a terrible teaching style. Number one, stresses the students out because...
Yeah, so the hot seat. You're always sitting there going, I hope I don't get called on today. And the only time you ever do get called on is the few times where you didn't happen to read. Guaranteed, it's... I don't know if you sit there and there's a look that you have that the professor can just see. Maybe you like radiate a certain color or your aura is off and maybe they're all Satan worshipers that have some kind of insight and they just know how to pick on you on the day that you didn't read. Yeah, it's a problem. It sucks. And being on the hot seat, you sit there and you're really, it matters none in your life except to be embarrassed that day in front of all your classmates.
because they're on the hot seat and they could be peppered with questions that they may or may not know the answer to. But on top of it, when you're the one that's being asked those questions, your brain tends to shut down and you don't really remember the actual exchange. And
I mean, sort of. It's sort of like being questioned as a witness in a case. A lot of times you won't remember your own testimony of what you gave. It's a weird experience. It just is
crazy.
It's kind of basically if you're ever afraid of public speaking, this is the worst form of it. Just the absolute worst form, because they're going to ask you a question, and almost anybody who is the person who's going to be answering those questions, you're the one that's going to possibly, likely, maybe be humiliated because what you say is likely to be wrong. It's that they're going to use your answer as an example of, well, yeah, there's that, and then it's sort of this sadistic domination type of thing. A lot of times it's weird. It's just weird. Some professors use it as a springboard to move things forward, or I don't know. It's one of the reasons why I don't ever want to be a law professor.
The thing is that most law schools don't give any classroom points for participation, or if they do, they give a very small amount.
They always tell you they can either raise you or lower you by half a point. I don't know whether that ever happens or not. And you know what? I don't even care. Take it off my score. Like in that, I was never that competitive in class because I didn't ever believe that anything about my life was dependent on my grades in law school ever. Grades through college, yeah, because that's used to get into law school. But once you're in law school, who's going to be looking at your grades? I don't ask our potential employees what their grades in law school were. And I don't know, maybe we should, but we don't, because that's how little we actually care. What I care about is what's your experience. Do you have clients that are satisfied with you? In me talking with you, are you a personable person? Can I tell that you know exactly what you're doing? I run some fact scenarios to see what you would do. I do a personality assessment of you on our own to see whether or not you're going to be somebody that would work well with our firm. None of that is necessarily indicative of your law school grades, because in law school you're already with the best of the best of the best, and somebody has to get the C's. Somebody gets an A, somebody gets a B, somebody gets a C, and the class average, when I was at SMU, they averaged to a B minus. Now they've moved it up to where they average to a regular B. But in law school, you've got people that have gotten straight A's their whole life that are gonna get their first C and be shocked, and it's because of a lot of times they're in class telling you certain things are important, but then they grade you on other things. And really the test of a good lawyer is figure out what they're grading you on, perform to the test, and do law school that way. I wasn't there for that. I was there for the knowledge. I didn't care at all what my grades were. So on classes that I didn't care about, I would get C's. On classes that I was really into and liked, I would get A's. Classes that I got A's on, entertainment law, intellectual property, negotiations, I got the highest grade in the class. Why? Because as a lawyer, what do you really do? And in negotiations is the only time you're really directly competing with other people in an actual measurable negotiation. On everything else, it was just, dog and pony show. Can you demonstrate that you understood the material? And I could, but a lot of the things that I was there for, if they were making me take a course that I didn't care about and I didn't want to know, I would get by with a C. And there's an expression in law school, and most people wouldn't do this badly, but it was D for diploma, D for degree. You get your degree and you get your diploma with even really low grades, and it doesn't matter. And if you pass the bar exam, you got the same law license that everybody else does, from the best of the best, whatever that means, to the worst of the worst, whatever that means. I would describe the best of the best as you serve your clients well, you get good results in the cases. If you can do that, then who cares what you got in law school?
For class participation. So all the stress that the Socratic method causes doesn't actually count for anything when you're in class. It's
insane. I agree. And all you're trying to do is not be embarrassed in front of your other classmates.
Insane.
And at a certain point, that becomes not very worth it to work for.
In addition to competing against each other for the top grade in this class.
I gotta tell you, most people don't really care about getting the top grade in the class. I didn't. I didn't care about that at all. You know what? Actually, I did. In entertainment law, I wanted to get an A. In intellectual property, I wanted to get an A. And in negotiations, I wanted to get the highest grade in the class. And so I did.
You will also be competing for one of my firm's highly coveted 4 internship spots next year.
So the 4 internship, that is a brilliant strategy. And that's why he's standing in that class. Why? Because he's trying to fill his firm with the right people. And who are you going to have to be your young lawyers that work and learn the ropes and do a lot of the work that you don't want to do anymore, because it's work that people need to learn how to do and can do, and it's the routine ditch digging equivalent of the legal work, and you've got to get new and young attorneys to be in there. Well, what's the best way to do that? Look through the class and take a semester to interview basically 50 to 100 people who are in that class, handpick the ones that you want, and especially if you can convince them that it's a coveted thing that you should try to get, and this is the job that you want, so they all apply and they really apply themselves to it, then that's a great way for you to fill your law firm. And he's got 4 spots of that. He's trying to fill 4 lawyers. It might be worth the time to do that. For one spot here, one spot there, it's usually not going to be worth the lawyer's time, because if he is $1,000 an hour attorney and he has to spend, let's say, 4 hours a week doing this times 10, that's 40-hour work week to get 4 employees. So that's 10 hours per employee. And so 10 times 1,000, $10,000 to find a good associate employee. Yeah, that's about what we wind up spending in order to find an employee. So it's probably a decent deal. But that's what he's doing. That's what they do. That is what's done.
Where you will get to assist on actual cases.
I've never heard of a full professor at Harvard or any other law school for that matter also being a full-time partner in a...
So that's the thing. We don't know if he's a full-time professor. What I'm assuming here is that he is an associate professor that teaches like one class coming in, and that's what the basis of his time was. If they are a full-time professor, they're probably not a partner in a law firm. They're probably just a professor.
A law firm at the same time, or at least I hadn't until I reviewed How to Get Away with Murder, which has a similar conceit and is similarly insanely ridiculous. It's also ridiculous to be offering an internship to one of his students based on the best grade. What you will see is that a professor will give a TA award to one of the highest performing students in his or her class. In other words, if you do really well in that class, you can come back the next semester or the next year and be a TA for that particular class, which is a highly coveted award and kind of a mark of distinction. And having a job your first year summer in law school is really important, because when you come back from the summer, that's when you tend to do interviews with the top law firms.
And those top law firms, they're going to take about the 10% of the class. So it is grade dependent. And those things pay like $2,000 a week. And they're doing that to highly entice you and for their own credibility. This is where law firms get a lot of their reputation from. And what they're doing, they're not paying you for what it is that you're doing there. They're paying you for what that reputationally causes in the community and in the minds of the other students, so that they can get people to come in and take a job at $125,000 to $175,000 coming out of law school as a first-year associate. And they're doing that because a lot of them will say, all right, they'll show you around the first day and they'll go, by the way, here's your cot. This is where you're going to sleep, because you're never going to leave here, because you have to build 2,800 hours this year or 2,600 hours. And that's basically you're working at 12 hours a day, 6.5 days a week, and it's insane. And you do that, and they burn you out the first 2 years out of law school, and they pay you okay for that. And people realize that real quick and get burned out.
So while this particular award seems very ethically dubious, the general concept is accurate, and you're trying to compete for 1L summer jobs. And
then the 1L summer jobs then turn into full-time positions in there. So this is definitely something that a larger law firm, they are trying to recruit the best students out of the law school.
And to get a TA award and be a TA for a professor.
Ms. Woods, would you rather have a client who committed a crime malum in se or malum prohibitum?
Malum, it's per se, or malum prohibitum, but malum in se. What that means, malum in se, is it's bad because it's bad. Malum prohibitum means it's bad because it's prohibited. For example, a lot of people would say marijuana is malum prohibitum, meaning it's only bad because it's prohibited. Otherwise, it's not bad in itself. Whereas murder is malum per se because it is bad in itself. It's not bad because it's prohibited. Like if we didn't have a law against murder, it would still be bad one way or the other. It's obvious. So at this point, I understand the long breath. I've studied a lot with world champion Olympians in competing for different things, and Lanny Basham wrote with winning in mind here, who was always on my desk. He explains, yes, take a deep breath, get some oxygen to the brain, help it function. But in waiting, I'm not sure that this professor might have even waited that long. And at that point, you just take a guess. But then you know that the professor is then going to say why, even if you guess. So I don't know. Sometimes it might just be I don't know. And I've also had people in class go, I'm sorry, professor, I don't know because I didn't read the assignment. Why didn't you read the assignment? Because I just didn't get to it. So it happens.
Neither.
And why is that?
She's probably going to say, because I would rather have a client that's completely innocent.
I would rather have a client who's innocent.
Boom. And actually, I wouldn't, because you've got somebody that's innocent. And this is why I don't do criminal defense anymore, and instead I do family law. If you got somebody that's innocent, that's the worst type of person to be accused of a crime. Because if you screw up or something goes wrong and a jury can see, you put your client on the stand and they're nervous and the jury thinks, oh, they're nervous, they're responding badly, so they must be guilty, and they convict them, then it's on you that you have sent an innocent person to jail because you didn't do your job well enough. I hate that. I can never sleep the night before trial. In family law, we're so well prepared. We know exactly how it's going to come out, and we also know what the judges are looking for, and it just, for me, it's just a better flavor of going to court. And I love going to court in family law, although most of the time in family law, we get to avoid going to court. 90% of all of our cases don't go to court at all. 99% don't go to a final trial. And so court is lawyer Disneyland, and we do great. But criminal defense, I did it for the first 5 years of my career. I haven't done it in the past 12 years. And to defend an innocent person, it takes a very special time. And, how do you know whether they're innocent or not? Most of the things that I did were like malum prohibitum type of things where no one was actually hurt, but somebody did something stupid or, and so that stuff wasn't for me. So if she would rather have a client that's innocent, that's impressive if she wants to defend innocent people. And for attorneys that are like that, my hat's off to you, because that is a difficult job.
I hate using legalese and Latin.
The other thing is about with her classmates and things laughing at her about that. That's weird. Obviously, that's Hollywood, putting that up and presupposing that that's a condition. But I don't think anyone would actually laugh at her about that.
It's a common misconception that lawyers are going around spouting Latin all over the place.
And none of us like the ones that do.
In reality, you really want to minimize the amount of legalese that you're using.
Exactly. You want to speak kind of like what Donald Trump does, which is third grade language. And I've seen a lot of different studies that third to fourth grade regular everyday language is more persuasive to everybody, even people with immense vocabularies, people that speak multiple languages, or people that are highly educated, to speak more plainly, precisely, and concisely in plain English, even though the word concise is not really me doing that. But simple English is always better. There's a book called Plain English for Lawyers, and it's to teach lawyers how to speak in plain English. Because he's right here, LegalEagle. Robots do make bad lawyers.
Because you don't want to use overly complicated words and phrases. You want to be as persuasive as possible and really as down to earth as possible.
Exactly.
So whether you are drafting something to a judge or talking to a jury, it's actually very rare that you're going to use obscure Latin phrases like this friggin' nonsense.
Yeah. And the problem is we still see it in a lot of pleadings. Or the worst is when we have somebody that's not a lawyer who's representing themselves who tries to use it, it's usually not done well, and it's ridiculous.
This is kind of a dumb question.
What's with the costume?
Oh, I just decided to dress up.
Really?
I feel like we barely get to see each other since we've been here.
Oh, I know. I'm so busy with these case studies.
If she dressed up as a pink bunny at a law school event, she would get made fun of probably forever. She would be remembered, though. Everybody would remember that. Everybody would remember Elwood's name.
Hypos.
So this is actually kind of an accurate depiction of the stuff that first-year students have to go through. You're inundated with cases that you have to read because law school uses what's called the case method.
Yeah.
So law students tend to brief every one of those cases before.
By the way, those cases have been briefed over and over and over again. Yeah, brief a few of them so you get it, but look at the canned briefs don't waste your time doing that. It's just this hell that you're going to go through, and it doesn't do anything rather than, I don't know.
Class. And at the end of the year, when you're given your final exam or in your midterm, you're given what are called hypos. And hypos refers to the type of essay questions that you tend to get on your final exam. For the most part in law school, you're tested based on a hypothetical set of facts. You're given a huge fact pattern, and then you have to answer all these questions, like how many crimes are being committed and explain why, basically.
So that's where you have to have all of your crimes memorized and all the elements of the crimes memorized. And so the way you actually answer these questions is you go through the question and you circle every fact, because every fact is there to raise some kind of issue. And you go through this thing called IRAC, which is issue, rule, application, conclusion, or CREAC, which is conclusion, rule, application, conclusion again. So you state the conclusion twice. And most of the time you use IRAC. And you're getting a point if you spot the issue. You're getting a point if you name the rule correctly. You're getting a point if you apply it correctly. And you're getting a point if you draw a conclusion, even if your conclusion's wrong. They tell you it doesn't matter necessarily what your conclusion is. It's just a matter of whether you go through that process in your exam and whether you've spotted all the issues. So the way you do that, circle every fact. Every fact leads an issue. Count those issues that you've got, and those are how many issues you have. And then you IRAC, issue, rule, application, conclusion. And they also tell you if you don't know the rule, make up a rule and just apply it, and then apply the rule to the fact, because you can still get the application point. You can get maybe half a point if your rule's slightly right or slightly off. In the bar exam, a little bit less, because the bar exam is more testing whether you're doing accurate knowledge or not. But it'll still carry you through and still add up those points. You can still pass the bar exam citing quite a bit of wrong loss, surprisingly. But that's how you answer and what you go through. But they're all these random questions. The other thing is, when you're in law school, they have these books of every previous exam that the professor has ever given all the past semesters, and you can do that yet ahead of time. So if you practice multiple choice questions to help you memorize the rules, and which is spotting all the issues, and then also to learn the fine line distinctions between, like, what's the difference between assault and battery and those different things, then you practice the multiple choice problems to teach you how to run the analysis, and then you practice the previous exam questions so that you know how to exactly write that out. And if you do that, you'll do well in your exams.
So that's a little throwaway line that's accurately describing what most law students go through.
It is.
Come on, you're never going to get the grades to qualify for one of those spots.
That's a pretty negative mindset. And if that's what somebody is saying to you, that's not a person you want to associate with.
You're not smart enough, sweetie.
I wouldn't say that.
Bye, Felicia. And he's Felicia.
Wait, am I on glue, or did we not get into the same law school, Warner?
So she's actually making a really excellent point, and this is another common misconception about law school, which is that people assume that the quote-unquote smartest people are the ones that are going to get the best grades.
Not true.
In law school.
It's actually the one that wisely approaches the problem, because intelligence does not particularly have as much to do with it as is your work process, not even necessarily your work ethic. As a matter of fact, people that like to get to the point and look through a case and go, I'm not going to just sit here and passively read this. What passively reading is like you're just reading and seeing what you get out of it, versus active reading is, what's the point? What am I looking for? Question to question. What's the next question? You're not reading it just from beginning to end. You're looking for the point of it. And they'll use different tools, like somebody else already briefed this case, so I'm going to read their brief. What's the point? What's the holding? And then I'm going to look through the original case and go, okay, I've got it. That can get through it quickly and then master the more quantity of the material in a faster way. That person, whether their IQ is higher or lower than somebody else in the class, that's the person that's going to get the A in the class, who masters that, and who also masters the big picture of how does this fit into the outline of this course.
School, as if knowing more law and knowing more facts will translate into better grades at the end of the semester. And in fairness, that is sort of the case in college and high school, where memorizing things by rote will generally result in better grades when you regurgitate those facts back to the professor. But this is not the case in law school.
That's correct. And the things that prepare you for class are not in any way the things that are going to prepare you for the tests. You've got to go through the test and prepare. And the fact that you're going to class is actually, and this you realize in your second, third year, it's one of those things that you're going, check the box, I went to class, I got through class without being embarrassed. But the class has nothing to do with actually what you're going to be tested on. I mean, sort of, kind of, sort of a little, but it's not a direct link. You have to do the practice. You have to understand how the things that you talked about in class fit into the big picture. And it's more important that you study and work the big picture and figure out how you're going to take that exam.
Once you get into the same law school, all bets are off.
That is absolutely true.
There is no reason to assume that Elle would not be able to get as good a grade or better grades than the rest of her classmates.
Exactly.
These kind of exams are all about application. It's about thinking like a lawyer.
Yep.
Where have I heard that before? It would be kind of like an engineering exam where you're not asked about formulas or about the history of engineering. You're asked in your final exam to build a car from scratch.
Yeah, and that's exactly what law school is like. However, in class, they don't talk to you about building cars at all. And you've never built a car in class. It's very detached.
It's kind of what you're doing, but from a legal perspective. So people often screw this up.
Big time. And it's shocking to them when they get grades because you go through the whole semester, first semester, and you take one test and that's your whole grade. And it's like somewhere between a 90-minute to a 3-hour test. And then it takes you about 6 weeks to 8 weeks into the second semester, and then grades come out, and more than half the people are just absolutely shocked. And yeah, it's shocking.
And the people who get the best grades are generally not who you think they are.
Correct.
You filed a claim. What next? Ms. Woods?
Okay, so you see that, like trying to wake up? That's a thing. You probably see half the class doing that at most points because some of this stuff, especially civil procedure, holy cow. And it sounds like she may be in civil procedure because she's going, you filed the claim, now what? So a claim would be a civil claim because otherwise they would have said you filed an indictment, as if they're talking to prosecutors, or an indictment has been filed against your client if you're criminal. So this is clearly something civil. You filed it, so now what? That's a big window. I could sit here and talk for days and days. Well, you have to get the thing served. Well, you have to start doing discovery. You have to send out your requests for production. You have to start doing your initial disclosures. There's a lot of stuff that you have to do. And so even this question, I just feel the tense and setup and going, oh God, what is she asking me? And now I'm going to look like an idiot in front of the class.
Don't you need to have evidence?
Well, technically, you needed to have some evidence before you even filed the claim or know that the evidence exists, because if you file a claim not even knowing whether there's evidence or not, you have probably committed a Rule 13 violation and they're subject to sanctions. You have to have good cause for filing lawsuits. And so I would hope that you have some of that stuff ahead of time.
Meaning you need reasonable belief that your claim should have, like, evidentiary support?
That
that
was a stupid question and a nonsensical answer.
I completely agree.
This is not a good example of a dialogue between a professor and a student at this point in the semester.
And the purpose of diminished capacity is
To negate mens rea?
That's actually right. So this is criminal law, obviously, and so every act called the actus reus is the act of doing whatever the act is, and then mens rea is the mental state. So, for example, the fact that I pull the trigger and a projectile comes out and strikes another person, how and why I did that makes a big difference. For example, if it was to intentionally, make someone not around anymore, and I didn't have any kind of defense or justification for that, then that would be considered murder. If it is something that I didn't even know that they were there, and I thought I was shooting at a target, and they happened to be behind the target, and somebody put a fake paper target to where whoever shot through that, the bullet would then go into the person behind them, and they had somebody standing there with, they said, put on a blindfold, we're going to take you for a surprise, and then they get shot. I wouldn't have had any kind of mental thought to try and make that bullet go through that person. So there's all kinds of different reasons that make something different. And so diminished capacity would be, I had no capacity. I didn't even know I was pulling a trigger. I thought I was at the amusement park, and I lost my mind, but it turned out I was doing something like that. It reduces your criminal culpability. So she's exactly right.
Okay, That is a reasonable question to ask, assuming this is a criminal law class.
Yeah.
And that was a reasonable answer. There's a concept in criminal law called mens rea. It means to be guilty of a criminal offense, and you have to have the mental capacity to have done the crime itself. Sometimes committing the same action is a crime, and sometimes it's not a crime, and it depends on the mental state. So when she's saying that the diminished capacity negates mens rea, that's sort of correct. That would mean that the affirmative defense of diminished capacity might negate the mental state required to be guilty of the criminal offense.
Dewey Newcomb?
Who's asking?
I'm Elle Woods, Miss Bonafonte's attorney.
Oh no, Elle.
Yeah, I see this is going in a bad direction. You never want to confront anyone like this as if they're going to care. This is a dangerous situation for her to be in as well. And usually you need a detective or something like that to go out and collect your evidence for you. You're not going to go out and do this yourself.
And I'm here to
Don't do
discuss
that. That is bad news.
Yeah.
Do not do that.
Yeah, I would be freaking out if one of our associates did this.
Come again?
Do you understand what subject matter jurisdiction is?
Oh my God. I'm embarrassed for her at this point. This was so not working. It was just Hollywood.
No.
I didn't think so. Well, due to habeas corpus.
She is just making stuff up at this point.
Which means produce the body. That's absolute nonsense in this context.
You and Miss Bonafonte had a common law marriage.
So common law marriage would be in Texas. They agreed to be married to each other between the two of them. They cohabitated for any length of time, and they held themselves out as presently married in the state of Texas to other people. The moment they have those three elements, they actually would be common law married in the state of Texas. I don't think this is Texas because I think, well, Harvard, she would have been in Boston. So I don't know if that's the law in Boston, but I don't know, maybe. And whether or not somebody's going to care about what she's saying, I would doubt it.
Which, heretofore, entitles her to what is legally referred to as equitable division of the assets.
Yeah, I mean, that's a real phrase that gets used in divorce proceedings, but it probably doesn't apply here.
It's called just and right division in Texas, but close enough.
This is insane.
It is insane, and they wouldn't care. He wouldn't
Come again?
care.
Due to the fact that you've retained this residence, Miss Bonafonte is entitled to full canine property ownership, and will be enforcing said ownership right now.
Oh boy. Okay, so what Elle has...
The other thing is, yes, and she's also pretending to be an attorney. Maybe she has a student bar license, which is a thing in Texas at least. It's around in a variety of different states. But you have to do that under the supervision of your managing attorney. And if you are doing something like this, I am pretty sure that her managing attorney did not tell her to do this. She's kind of out on her own rogue. It's a felony to do that in the state of Texas. Maybe she could get away with it with the student bar card and under the supervision, maybe her managing attorney would cover for her or something like that. But yeah, don't pretend that you're an attorney ever. It's a felony. It's a crime.
Has done here is she has pretended to be an attorney. She hasn't finished law school. She's never passed the bar, and she has absolutely no right to call herself an attorney.
So by the way, if you do this as a law student, you will be expelled from school and you will be prohibited from ever becoming an attorney. So this will be the closest that you ever get to practicing law.
And when you do that, that's called the unauthorized practice of law.
Exactly.
She has held herself out as an attorney. She's essentially committed a fraud against this other person. And as a result, she's committed a huge ethical violation.
Yep.
So if anyone ever finds out that she committed this unauthorized practice of law while she was at Harvard Law School, she would probably be barred from entering the bar in virtually any state in the United States.
Yeah, for forever. And they tell you this in orientation, they tell you this a lot in law school, that you must not give legal advice. Actually, you can give one piece of legal advice. You should hire an attorney. That's the legal advice that you can get, is that you should hire an attorney for that. That's it.
I hate to see this both for the ethical lapse of judgment and as just someone bullying a layperson.
Yeah, don't do that. And it wouldn't even work. And it goes over well.
10 people.
It does not go over well.
Saw her downing Cosmopolitans at the Caribou Club.
Well, all I know is that it's not Brooke.
That's touching out. But we need an alibi.
All right, I think they're confusing alibi with an alternate suspect. An alibi is something that you have to show you were not the one responsible or could not have done the crime that was...
I don't know. Alibi is fine. If he wants... An alternate suspect is less powerful than an actual alibi, because if you've got an alibi, then that can corroborate that it wasn't you, because you were in a different place and couldn't have been there at the time that you were there. So I could see both.
Was committed, an alternate
splitting hairs there.
Suspect is someone else who could have committed this crime. And they want to have both, but they already know their client doesn't have an alibi because she was the one that found the body. So they're going to have to do their best to come up with an alternate narrative. But it's important to note here that while an alibi or another suspect might be nice to have, it's not necessary for a criminal defendant to be acquitted.
That is
might
true.
want to have it, but again, the defense doesn't have the burden here.
Correct.
They don't have to prove anything. It's the prosecution that has to prove their case beyond a reasonable doubt, which is the highest burden in all of criminal law.
We got 2 interviews tomorrow. Gerard and Bobby are going to handle the ex-wife in an hour. And according to this communique from the prison, our client apparently had a visit from her sister, a Miss Delta Nu.
So she's busted, and this would get her fired probably.
How much time are these law students spending on this murder trial?
Well, if you're in a murder trial, first, as a law student, you're not going to be in a murder trial. No one's going to let you do that. You would have to do several misdemeanors first, and then maybe you could do one type of very low-level felony. A murder trial? Absolutely not. I don't think any judge, I don't think any licensed attorney would allow a law student to be as involved in this as they are. And especially, you've got a law student that's pushing the ethical lines like this, she'd be out.
They're in the middle of their first semester at Harvard Law School.
Yeah.
Harvard is not like Yale in that they've done away with letter grades. If anything, letter grades are bigger and badder in Harvard than anywhere else. So
Yeah, and nowhere does this your first year. At best, you would be second year for a criminal defense clinic, like I actually did in law school. But first semester, there's no way.
how are they spending hundreds of hours a week on this murder trial team as an intern while ignoring their law school and their law school grades? They're going to get terrible grades. They're going to fall behind in their reading and all the rest of their classes.
I mean, they would be getting zero sleep. I'm not kidding about that. Zero sleep. There were some semesters that I had in law school. One semester in particular, my third semester, which was beginning of the first semester of my second year, where I would be awake for 36 hours and then I'd sleep for 12. That was my schedule. I did that twice, and then I would have like a 12-hour day and a 12-hour sleep. And I did that for 10 or 12 weeks in a row. It was insane because I was taking 17 actual hours that really were the equivalent of 21 hours, because I had one 2-hour class that was the work of a 5-hour class. I had another 2-hour class that was the equivalent of a 5-hour class. And then I had my other classes, like some of the 3-hour classes were actual 3-hour classes out of 4-hour class. And it was the workload of about 21 hours, which is 21 hours in class. It's 84 hours out of class. Plus I worked 35 hours a week at waiting tables so that I could be in law school and feed myself and live. And so I got extremely little sleep for about 10 weeks. And I still have a sleeping disorder from that.
This is not smart if they actually want passing grades in the classes that they're already in.
Did you ever take Mrs. Wyndham on a date?
Yes.
Where?
A restaurant in Concord where no one could recognize us.
So that open-ended question, where, you typically, when you're cross-examining a witness, you want to say, and you did this, didn't you? You want a yes or no answer. If he says where, sometimes they'll give you this weird answer. You never want to ask them a question that you don't know what the answer is going to be. So that was a little bit risky of a question, but not. I mean, I've seen that before. It's not bad. It's okay.
And how long have you been sleeping with Mrs. Wyndham?
3 months.
That's a good question, and the fact that he said that.
And your boyfriend's name is
Chuck. Right.
And that is one of the techniques. You ask someone questions, and you get them on a roll of answering the questions, and then you ask them the one that they're in the process of, and they're going to finally tell you the truth on the one that you think that they're going to lie to you for. That is a technique that's used a lot.
All right. So this is a little ridiculous, but what this attorney has done is employ a tactic that is actually used by actual trial attorneys. And that tactic is to get the witness in a habit of agreeing with you. You ask a string of questions, and it doesn't have to be as rapid fire as here, but you ask unobjectionable questions that you know the answer to, and you know the witness is going to answer yes or no. And it's only at the end, after you've trained the witness, do you ask the question you really care about. And by then, it's too late. So it actually can work like that.
And does. Although sometimes you get some surprises of answers. Because one time I was doing that, and we were asking a bunch of those yes questions. So, and you were married for 18 years? Yes. And you had 2 kids? Yes. And you were in love with your husband when you got married? No. What? That was supposed to be one of the yeses. What, you weren't in love with your husband when you got married? No. Have you ever been in love with him? No. Why'd you marry him? Because of the way he made me feel? How'd he make you feel? Like I was special? But you were never in love with him? No. I need a recess. I get a call. Summer, I need you to answer this question honestly. Were you in love with me when we got married? She starts laughing at me. Yes, Palmer, why? You wouldn't believe the answer that I got today. So it does
a little
work.
bit, sort of.
Silence! Pardon me.
Yes, Mr. Salvatore.
I was confused. You see, I thought you said friend. Chuck is just a friend.
Oh, okay.
You.
Okay, you love when that happens, but it usually doesn't.
Chuck, wait!
Although he wouldn't have stood up and made a spectacle like that in court, but he might have just stood up and walked out and then not talked to the guy. No one else would know. It's nice to have that confirmation, but that doesn't usually happen in real life.
Silence in my court!
All right. The judge has to keep control over her courtroom, otherwise it's prejudicial to the defendant. But what happened outside of that witness's testimony is not evidence. The jury should not be able to take that into account.
But if they saw that, the jury would take that into account. It's hard to put that cat back in the box.
The defendants really, really should call that man, Chuck, to the stand and ask him questions about his relationship with a prior witness.
That would be good. Although, haven't seen that, and a lot of times you're very limited on time, I might have been okay to not present that to the jury.
I have a feeling they're not going to do that, which is basically malpractice.
Not necessarily. If you're in court and you're in trial and you have a certain very limited amount of time, in a murder trial, they give you more time. But for example, I was in a jury trial a week or 2 ago, and we had 4 hours to do the entire trial. And the other side used all their time, and the judge gave us both an extra hour. We still had to make choices. And a lot of times, if that witness is not that important, minutes, just 1 minute, 2 minutes, 3 minutes is important, because you've got everything laid out of, I got to get this from this witness, this from this witness, this from this witness. And you're sitting there with an assistant who is timing you on all this. And if you go long on one person, you got to make it up somewhere else. And it's very, very difficult. And if they're objecting to you, then that can take you even longer than what you thought. And you may have even done rehearsals just to get it down to that 4 hours. Well, if something like this happens and you're not expecting it, to say that it's malpractice to not bring them back, no, it's not. You have to make choices in these things. So, I mean, could it be malpractice? Maybe. Who knows? You get a not guilty and you're the defense. Nothing that you did was malpractice, unless it's something that undoes the not guilty verdict or something. I mean, there's certain things, but if you're a criminal defense attorney, a not guilty verdict washes away a whole lot of criticism about almost anything.
But that guy should be on the stand so you can get his reaction to the testimony.
I mean, and if I did that, it would be a, what's your name? And who's your boyfriend? How long you've been in that relationship, whatever. And you've been in that relationship, and you heard him just now testify on the stand that he is not that you're just a friend. Is that true? No, it's not. That was a lie. Yes. Something like that. But what are you doing? I mean, you're impeaching that person's testimony. I mean, the jury can look at that guy who said, no, he's not my boyfriend, he's just a friend, and notice the guy walk out. I probably would save the time, honestly. And I don't think that would be malpractice, but it just depends on the case.
And establish that the other witness has perjured himself.
I think it's time to discuss your career path. Have you thought about where you might be summer associate?
Oh, this is not good.
Not really. I know it's very competitive.
Well, you know what competition's really about, don't you? It's about ferocity, carnage, balancing human intelligence with animal diligence.
I don't like to focus on the animals.
Knowing exactly what you want.
I mean, obviously this is Hollywooded up and playing on this cliche of what people think somebody is. I can't see. I don't know. I don't know if I'd ever. I don't know. It's just so foreign to me of something like this happening. I can't see it. I don't know.
And how far you'll go to get it? How far will L go?
Oh, God. All right. I called it.
Yeah. You do not do anything of the sort ever. my wife works in my law firm, but we were married first. And so I did not marry my paralegal. I paralegaled my wife.
What a creep. What a creep. As we've seen in things like Suits, this is an example of quid pro quo sexual harassment.
It is.
Now, the professor wasn't quite as explicit as the episode of Suits that we reviewed, but unfortunately what he's done here is implied that she could get a summer associate position and potentially...
He totally implied that ahead of time. It is.
Take a full-time position with...
If you're going to do that, I mean, I don't know how you would even ask an employee out in the legal profession how you would do that. It's just a bad idea to do that. Man, I don't know. I can't see it. I have no idea. I don't think we've ever had that happen in our firm. Thank God. I don't ever want it to happen in our firm because we, in general, because of the motto of our firm, and we focus on things that are healthy, we support good families. We want our firm employees to have good relationships and things like that. So thank God we haven't had to deal with this.
With his firm if she agrees to his sexual advances. That is classic quid pro quo sexual harassment. It's super gross, and I hope she sues his because that guy's a jerk, and... All right, so now it is time to give Legally Blonde a grade for legal realism.
Okay, so legal realism, what would I think? Well, you know, the thing about it is that he missed something massive. They would not be on a murder trial. The fact that this is legally realistic, I mean, she committed 2 ethical violations, with one impersonating an attorney, another impersonating someone's sister. In order to visit a client in jail, you don't have to say you're a sister to get visitation. You say, I'm a lawyer, I'm here to visit my client. Even if it's not visiting hours, in a hospital, a lawyer can visit their client. Even when COVID was happening, there was an instance where I almost had to go in against a COVID regulation. It worked out to where I wound up not having to do it, but they could not have legally deprived me from going into the patient's room. Just like the doctor that works at the hospital treating the patient, I'm their lawyer, I could have gone in. And you can do that in a hospital, and you can do that in jails. Even if it's not visiting hours, they have to reasonably accommodate you. Now, do you want to go and tick off a warden or the jailers? No, you try and work within their realm and reason. And that's why the thing going on in Washington, where the lawyers can't even get access to their clients in the federal prisons about the January 6th stuff, is so shocking and further horrible. You're allowed to go visit them. All she needed to do was say, I'm here, I'm her student attorney, here's my bar. You get a student bar license on this, and you just show that and show the authorization, and probably take in a written letter showing the authorization from the managing attorney, and they should have let her interview her, no problem. And she could have probably recorded it too. If not, she could have taken very, very detailed notes. And if you are in those jail interviews, they're recording it. Probably they're not supposed to record lawyers, but a lot of them do. And so she could have done that. And if she goes in and says she's your sister, then that's definitely going to be recorded and not attorney-client privilege. So either one of those two things probably would have gotten her kicked out of the program. A couple of things were realistic. The Luke Wilson cross-examination, that was actually pretty good, but I would give it a 2, I think, as far as that. And just because the client who's in jail, no matter how much money she wants to pay, wants somebody working on the case, not going to be persuasive. I would happily let that client go somewhere else, because I wouldn't be a part of it, because I'm not going to let a first-year law student commit malpractice on my law license, because as a supervising attorney, they're basically operating as an agent of yours under your law license. So the managing attorney, whoever her managing attorney from the school was, they would be responsible for that. And would that happen? Absolutely not. Would she have that genius moment in the courtroom of, hey, she couldn't have had her hair done, because the whole movie turns on the fact that she realizes, oh, the lady got a perm, and if she did that, she wouldn't have gone and done this, and that was the key to the case. She could have totally done that from the audience, passed a note to the attorney, they would have realized that, and it still would have been fine, but they would have had a professional attorney doing cross-examination. As a law student, especially a first year, first off, they got to trial way faster. If she started this as a law student and was arrested, the trial wouldn't be for months and months. Sure wouldn't be her first semester still. So, I mean, she would have had to learn criminal law and evidence is a 1 or 2 semester course, usually not until the second year at the earliest. And so she wouldn't know how to do objections. I mean, it's logistically impossible. They never would have let her do a felony. But I'm instead of a 1, I'll give them a 2 because of a couple of few things in there that were kind of legally realistic. So let's see what the Eagle does.
On the one hand, there are some accurate depictions of law school. Studying hard for the LSAT and getting a good grade that would get you in, and lots of case reading.
Yeah, for that, I'd maybe give him another point, bring him up to a 3.
On the other hand, lots of legal tropes that make absolutely no sense.
Yeah.
Complete
Hollywood.
Gibberish when it comes to legal discussions, and absolute malpractice in the middle of a trial. So I will give Legally Blonde a very, very gracious B-.
No,
I object.
Would I even give him the D for diploma? Maybe. I'd give him a 2 or a 3 out of 10.
On the other hand, one of the accurate things about Legally Blonde is that Elle Wood studied her ass off for the LSAT, got a good score, and got into one of the top law schools in the country.
But it's easy to write that into a script. She did it because it was in the script. How realistic is it for an actual human being to do? It's tough.
Which is a very similar story to my own. I was actually able to raise my LSAT score 15 points by studying.
So that's pretty good. And if you are going to go to law school and you are going to study for the LSAT, get one of these. LegalEagle, I'll step off or step into or boost up your ad here for being so gracious as to, unbeknownst to you, let me comment on your video. So, but if this one's good and you're recommending it, cool. There used to be some other ones, PMBR, Barbary, although those are bar preps. I think even more than LSAT. So the bar prep courses are going to save you time and help you easier take the actual bar exam. You want to make sure you pass the bar exam first time, because I will tell you that my law school now has a policy that if you have failed the bar exam, you're ineligible for employment at our firm. So you fail the bar exam on your first try, and you're not going to get a job with us. But the LSAT, in studying for that, that's where you're going to get your scholarships. That's where you're going to make more money by not having to pay as much for law school. So, and the difference between doing 10 points better or doing 15 points better, 15 points is a lot. You're probably going to get money for it. If you're doing well enough to get into some law schools, you increase your score by 15 points, that's a lot.
Studying and learning the tricks of the trade, and that's how I was able to get into one of the top law schools in the country. Getting a good score on the LSAT is by far the most important thing to getting into a good law school. It's more important than your grades, it's more important than your college, it's more important than your extracurriculars.
Absolutely, because it's an actual number score that all law schools use to compete for those rankings in the magazines so that they can charge more money and make more money, get higher donations. It's absolutely what law schools are looking for. It's all about that LSAT. You could even have a lower GPA, but if you raise up their average LSAT score, you're gonna be way better.
It helped me learn the tricks of the trade when it came to logic games and reading comprehension. Their methods are top-notch. You can take a live class, you can take an online class. You'll have fun while preparing for the LSAT, but more importantly, you're guaranteed to raise your LSAT score or your money back. Blueprint LSAT students raise their LSAT scores by an average of 11 points. And
so that by an average of 11 points, it's the same thing. It makes that program sound good. It's the same thing that the law schools do by saying our average LSAT is a 165 or a 172 or a 152, whatever it is. Those law schools are wanting you to be above their average.
So, do you agree with my grade for Legally Blonde? Leave your objections in the comments, which I will either sustain or overrule. And check out this playlist over here with all of my other legal reactions, including Suits and How to Get Away with Murder and Better Call Saul. So just click on this playlist, and I'll see you in court.
Well, you better hope that you don't see me in court, but I will see you in the next video. This is the Lawyer Dana Show. Pink tie. I guess maybe I did that a second. I need the whole thing. Oh. He's not going to stay for this. He is the hardest one for me to hold like this. Okay, Worthy. You want to watch this video? I think you don't. I think he doesn't. He's not interested in legal stuff. Fluffy dog, check.